TUPE is really important for any form of outsourcing, has a big impact upon the employment arrangements. The government has been consulting on changing TUPE, removing some of the gold plating, and has just announced what they plan to do. In this Q&A, I'm going to talk to Jane Fielding about what these new changes to TUPE are and the impact they will have. Jane, what are the key things to remember generally in TUPE?
Well, there are two main things to remember at all times, really, if you're not familiar with TUPE. The first one is to remember it's all about employee protection. The PE bit in TUPE stands for protection of employees' employment. And that's a key thing to bear in mind because that's how tribunals will approach things. The second thing to remember is that you can't contract out of it. So between the transferor and the transferee, they can't agree that TUPE won't apply, but what they can do, obviously depending on the strength of bargaining positions, is agree to kind of reallocate risk and responsibilities within the contractual documentation. So no contracting out is a key thing.
I've heard that the TUPE reforms are good for employers. Is that true?
Well, the main reason they're good news for employers generally is that the government was very focused in its consultation around TUPE reform on repealing the service provision change definition of transfers, which came in 2006 to address the fact that lots of outsourcings and insourcings were being considered to be TUPE transfers under the old definition. And this was brought in to bring certainty to the outsourcing situation. And the government's actually decided now not to repeal those, so those will stay in place, which most respondents to the consultation thought was a good thing. It gave certainty. And then there were some also more helpful changes that the government had brought in, making redundancies, for example, changing terms and conditions slightly easier and more straightforward in a TUPE scenario.
How do you know if you have a TUPE transfer?
Good question. Well, ultimately, only an employment tribunal or a court can tell you that you definitely have one or not. It's a question of fact with the legal test applied to it in every case. So often the application of TUPE is assumed, but you have to consider two tests. One is the business transfer test. So that's what's most commonly going to be present in a merger and acquisition, for example, a straightforward sale of a business. And that's the transfer of an economic entity which retains its identity before and after the transfer. The second test is a service provision change, and that's where you have an organised grouping of employees whose principal purpose is providing activities for a client, a customer. So that's the sort of outsourcing, insourcing situation. And you need to consider both tests whenever you're looking at TUPE.
What is the suggested new SPC wording?
At the moment, we're not quite sure because although the government has announced how it wants to change TUPE and the proposals for doing so, they haven't actually published the draft regulations yet, so we're not getting those until December. But what they've said they want to do is to add to the service provision change definition and bring it into line with where case law has got. So in terms of the activities before and after the change, after the transfer, they're going to bring in the wording that case law uses, which is around the activities being fundamentally or essentially the same. So it's going to be along those lines, although they have said they may not use those exact words.
Are there some benefits for the incoming employer of these changes?
Yes, there are. There's the overall certainty, as I said, that service provision change isn't going to be repealed as a separate test. But there are also some other amendments which should help transferees in terms of gauging risk and having a bit more flexibility around a TUPE transfer. So there are some changes around redundancies. There are changes around changes to collective agreements. And the government are also trying to make it slightly easier to change terms and conditions in a TUPE transfer context, which at the moment is quite risky. There's a high risk the changes will be void.
And what about the transferor, the outgoing employer? What's in it for them?
Overall, apart from this element of certainty around service provision change, I would say more of the changes benefit the transferees than the transferor. For example, transferees are going to be entitled to get employee liability information 28 days before the transfer rather than 14. Obviously, that slightly adds to the burden for the transferor who's providing that information. But of course, in an outsourcing environment, in that sector, what goes around comes around. So the transferor on one transaction may well be the transferee on another, and so sees the benefit from that side of the fence.
Will there be any effect on harmonisation of terms?
Unfortunately not. So there's no proposal to relax the rules around harmonisation. So harmonisation still won't be permitted as a result of a TUPE transfer, because it still won't be caught by the sort of saving provision which allows changes to terms and conditions as long as there's an economic, technical or organisational reason. And that requires a change in the workforce, which of course harmonisation doesn't involve. You've got the same people doing the same job in the same place. You just want to change their terms. So no, harmonisation will still not be allowed.
Is there any impact upon collective arrangements?
Collective agreements is an area where the government is actually making a couple of very important changes for transferees particularly. So just as a reminder, collective agreements are agreements between unions and employers, but certain terms can be incorporated into the contracts of employment of individuals, which means that they will transfer over to the transferee. The government's introducing two key changes around collective agreements. The first one is that they are going to build in an ability for a transferee to change the terms of contracts of employment that derive from collective agreements once a year has passed after the transfer. And the second is they're going to build into TUPE, into the new regulations, a statement that the transferee inherits collective agreement terms in a static form. In other words, if there's a collective bargain a couple of years down the line that they are not party to, because they're not part of the original collective agreement, they won't be bound by any changes that are agreed in the future. So it's a static, not a dynamic approach.
Will redundancies be affected?
Yes, there are changes affecting redundancies, and on the whole these are beneficial for the transferee particularly. So the first change is where you're in a collective redundancy scenario, you've got the right level of people triggering the collective consultation obligations. The transferee and the transferor are going to be able to agree that the transferee will consult with the employees affected before the transfer, which at the moment it does happen in practice, but it's not necessarily going to count towards discharging a statutory obligation. So that's helpful. That means that the transferee can get ahead of the game, if you like, in terms of consulting before they actually take the employees on. And the second is the government is going to change the definition of an economic, technical or organisational reason which can be used to prevent an automatic unfair dismissal. They're going to change that so that geographical redundancies, relocations, are caught, and that is a good thing. What they're not doing, which they talked about, is allowing the transferor to implement redundancies on behalf of the transferee. That will still remain prohibited. So that will have an impact on timetabling and the risk analysis in a transaction.
What should in-house lawyers do to prepare for the changes?
Well, I think there are three key things. First of all, keep an eye out for the draft regulations when they come out. As I said, they're expected to be before Parliament in December, which means we should get them either in October or November. Make sure you understand the kind of different risk profile now with some of these changes in TUPE, how that's going to affect your commercial negotiations. And in the short term, make sure you're aware of what transactions are coming up in the business where TUPE might be triggered, so that you make sure that you have all of that new knowledge about the risk profile ready for those urgent transactions that are coming up.